record on this case on cause number 238378 Costello versus JRD LLC. Counsel, with your appearances.
Brett
Counsel,
Levinson.
make your appearances.
Brett Levinson here for JRD LLC. Masalaka Powerline Services and JRD Texas LLC, DBA Masalaka Powerline Services.
I think Mr. Gobert accidentally signed
Yeah.
on.
Well, no, yeah, the live stream thing came up and I thought I was killing the screen and I was not.
Yeah, you're not the first one to do that. It's a little confusing. So, all right, make your appearances, Mr. Gobert.
Michael Gobert, on behalf of the plaintiff, Fred Costello, and Carter Boisvert out of the Austin office is my co-counsel. He came down with the flu yesterday and is not going to be on, but I wanted to mention that on the record.
Okay, let's proceed.
I think Michael set this for a hearing, but I guess it's my special exception, so I can just walk down them if you don't mind, Your Honor.
Sure.
Yeah, and I can do that either way, Judge, if you want me to, go first. But
If
I think
if it's his special exception,
it makes sense for him to go.
Fair enough, Your Honor. Thank you, Your Honor. The first item that we are specially accepting to are paragraphs 12 through 16, and basically, Your Honor, I've stated that he hasn't pled specific facts showing a contract between plaintiff and my client, JRD. Specifically, there aren't sufficient facts to show that that the plaintiff is a third-party beneficiary.
Okay. Respond.
Judge. So he's specially accepting to count one breach of contract, which is paragraph 12 through 16. Specifically, as I always do, paragraph 12 incorporates all the allegations from the complaint into the specific count, and then we lay out the counts. Defendants in the city of Garland entered into a valid enforceable contract for heavy construction to be performed near plaintiff's property, pursuant to which plaintiff is a third-party beneficiary. I then plead all conditions precedent for us to recover are present, that they materially breached and that we suffered damages. If you go back to the factual background, the first sentence of the petition says defendants, and there's two defendants. There's a company called JRD LLC, DBA Maslaka Powerline Services. They're the ones who originally started negotiating and bidding on this project. They then created this entity called JRD Texas LLC, which is a DBA for Maslaka Powerline Services as well. And from what I gather, it looks like they collapsed the one entity into a Texas entity because they needed a Texas entity in order to do this work for the city of Garland. So now it looks like they're saying now the only correct defendant is JRD Texas LLC. I went ahead and sued the original entity and that entity. Defendants, plural, first sentence of the factual background, contracted with the city of Garland to perform certain heavy construction on property near plaintiff's residence. Defendants performed the construction at or near plaintiff's property. They failed to act in a commercially reasonable manner with regard to the construction in the property. They failed to properly oversee contractors and subcontractors, committed breaches and or torts against plaintiff, which caused damage. Then I go into express detail that they traveled back and forth going east and west along the property. They crossed over the property. They were installing poles at the lake right behind the property. I say near the property. And I say specifically the equipment that was used to go into and do this work, and that they did it all with right-of-way access. And my client being a third-party beneficiary, how my client who owns the property that the city of Garland and JRD Texas contracted to do work on and near isn't a beneficiary of the contract when he pays property taxes and he's literally right there being affected by this. we've given more than adequate notice under the notice pleading state of Texas. I even say they used equipment including the crane, the vibro hammer, an excavator, a drill, a backhoe, extensive detail, and say that equipment caused damage. They drove dump trucks, field trucks, haul trucks, 18 wheelers, and others over my client's property. And then I say, because of this extensive work, it caused damage. I go one step further, Judge, to say the damage included specifically damage to the pressurized PVC irrigation piping, fencing, pool, foundation, plumbing, as well as other damages, which has already been assessed by an expert.
Mr. Gilbert, I get all that. I'm trying to figure out how your clients, I understand how you may have a tort for property damage, I guess, but how are they a beneficiary of the contract?
Because I don't know how they can't be when his property's there, his property's being affected by the contract. He's a taxpayer in Garland, and he's literally these contracts are between the city of Garland and between this power line company, and they're literally going over his property. I don't know how he's not a beneficiary of that contract. And at a minimum, I think I should be allowed to take discovery and get a copy of the contract and look at the bidding process and see how they map that out and plan that for that subdivision, because this was literally done at or on his property, right? I mean, literally right behind it, and they had to access his property to do it. So, I think I've pled the elements for purposes of special exceptions. Whether he wants to bring a summary judgment motion down the road after we do discovery, I think I've demonstrated vis-a-vis giving him notice of the claims of that particular claim. And Judge, he's got a special exception on my negligence claim, my gross negligence claim. All the same arguments apply.
I totally get your negligence, potentially your gross negligence. I don't know enough about the facts. I just don't see how this is how your client's a third-party beneficiary of this. Anyway, response.
Yes, Your Honor. I mean, I think that's the first one. The first item that I special accepted to centers around the third-party beneficiary, and I'm at a loss for words. I don't know how I'm getting fair notice that we're a third-party beneficiary of this contract with the allegations and the facts that Mr. Gobert has stated in his petition. I just don't see how we get to that. The negligence claim, the next one I specially accepted to, I can vacate that special exception. But I think that the gross negligence, I don't see specific facts that rise to the level of gross negligence or that he is.
All right, I'm going to require you to, and Mr. Gobert, maybe I'm just missing something, but
what's that? I'm sorry.
But I'm going to go ahead and order you to replead on the gross negligence and on the breach of or
the third-party beneficiary contract.
Third-party beneficiary contract. It's pled as a breach of contract, it looks like. If you look at this, so I don't know if that's
correct.
But anyway, I'm just trying to wrap my head around how this is how you could be a third-party beneficiary, but maybe there's something I'm not seeing.
Well, and Judge, Carter and I practiced together a long time, and I have certain skill sets and he has certain skill sets, and I wanted him to be on to actually address, some of the legal arguments, and I apologize he wasn't. But so your order is you want me to replead count 1, the breach of contract, third-party beneficiary claim, and count 3, gross negligence?
Yes.
All right.
No need to replead count 2, and you'll have
30 days.
14 days.
Okay. And
then go ahead and get me Mr. Levinson, get me a proposed order on this, unless you already have. Let me see.
I don't know if there wasn't one.
Yeah. Go ahead and get me a proposed order on this. At the beginning of the order, it should say this was heard on October 9th, 2023. Share a copy of the order with Mr. Gobert and get the order to me by no later than this Thursday.
Yes, Your Honor.
Okay.
All right, thanks, Judge.
All right, guys. And you guys have a great rest of your day. Okay.
Thank you, Your
Thanks.
Honor. You excused?
You are.
Thank you.
Right. Our next hearing is at 4 o'clock, I believe. Or is it 4:15? Let me see. Wow, my computer is really, really slow. What, Rhonda, when's our next hearing?
You're correct, Judge, at 4 o'clock. That's what I have on mine.
Okay. So Tony, take a quick 10-minute break and we'll see you guys at 4 o'clock.